To the surprise of many, including, I'll be honest, myself, the Supreme Court has denied Donald Trump's bid to stay his criminal sentence. He is scheduled to be sentenced tomorrow to no jail time, but as of tomorrow, he will officially be sentenced for the 34-count felony conviction in New York. The Supreme Court asked and answered. They have said no to Donald Trump's bid to stay his sentencing.
Hi, everyone. Adam is here. So what just happened? The Supreme Court of the United States, all 9 justices, conservative and liberal alike, looks at a president's claim that he is untouchable, that he is immune from investigation, that no subpoena can reach him, that no probe connected to Jeffrey Epstein can get anywhere near him, and says no, unanimously.
Donald Trump has asked the U.S. Supreme Court to intervene, just days before the president-elect is set to be sentenced for his conviction stemming from hush money paid to a porn star. In a filing made public on Wednesday, Trump's lawyers asked the High Court to immediately order a stay in the case, as Trump seeks an appeal to resolve questions of presidential immunity.
By the way, I did nothing, absolutely nothing wrong. If I did something wrong, I wouldn't be standing here right now because I've won all these cases.
Trump, who won another term in the White House and is set to take office January 20th, was convicted on 34 felony counts by a New York jury for illegally hiding payments to adult film actor Stormy Daniels, meant to buy her silence about what she says was a sexual encounter with the former reality TV star. Trump has denied the encounter and any wrongdoing.
No dissent, no nuance, no carefully carved-out exception, just a flat, definitive, unmistakable rejection of the entire argument. That is not a legal setback. That is not a procedural loss that can be appealed or worked around. That is the highest court in the land telling the most powerful person in the country that he is not above the law. Not on this, not on Epstein, not now, not ever. And that is exactly where we are right now.
Breaking news on a story that we just brought you. The Associated Press is reporting that the Supreme Court has rejected President-elect Donald Trump's bid to delay sentencing in his case. Mr. Trump is set to be sentenced tomorrow. He was found guilty in May on 34 felony counts of falsifying business records related to a hush money payment ahead of the 2016 presidential election.
The Supreme Court has rejected Trump's blanket immunity claim in the escalating Epstein investigation. The ruling is clear, it is unambiguous, and its implications are going to unfold faster than most people realize. No ex-president receives a free pass from Epstein-related probes. No blanket immunity shields a former president from this kind of scrutiny. Subpoenas for his personal testimony and his documents are now fully greenlit by the highest legal authority in the United States.
A federal appeals court rejected President Trump's claim that he's immune from criminal prosecution related to his alleged efforts to overturn the 2020 election, including actions that led to the January 6 attack on the U.S. Capitol. The ruling states, "We cannot accept that the office of the presidency places its former occupants above the law for all time thereafter."
Whatever protections he thinks he may have, because he's a former president, he doesn't have. He's a citizen Trump.
Trump showing his discontent with the decision, posting online, "A president of the United States must have full immunity in order to properly function and do what has to be done for the good of our country."
The legal wall that the Trump team spent months constructing, the immunity argument they were counting on to keep investigators at a safe distance, has just been demolished completely by the Supreme Court unanimously, and the implications of that demolition are enormous. But here is the part that should make every single person watching this video stop and really pay attention. While the Supreme Court was delivering this historic ruling, the DOJ was simultaneously caught withholding over 53 pages of documents specifically related to Trump assault claims. This was not discovered through political opposition research. This was identified through a detailed and careful NPR analysis of court filing stamps. 53 pages deliberately withheld, while Trump's own signed transparency law, a law with his own signature on it, sat on the books explicitly requiring full disclosure of these files. His own signature, his own law, his own DOJ defying it and hiding 53 pages of the most sensitive material in the entire Epstein file set. And Trump himself, 5 full days after the Supreme Court ruling came down, has said absolutely nothing meaningful about it publicly. 5 days of silence. The man who posts about everything, every perceived slight, every sports result, every foreign policy development, every random thought that crosses his mind at 3 in the morning, is silent for 5 full days on the single most significant legal ruling of his entire political life. And behind the scenes, according to multiple leaks coming out of donor circles, GOP donors are in a full panic. The phones are ringing, the money is getting nervous, the coalition is beginning to crack in ways that are going to be very hard to repair before the midterms. Here is what the mainstream coverage keeps getting wrong about this story. Everyone is focused on the drama of the Supreme Court ruling itself. And yes, it is dramatic. It is historic. It matters enormously on its own terms. But the bigger and more important picture is what this ruling means in the context of everything else that is already in motion around it. This ruling does not exist in a vacuum. It does not land on a clean slate. It lands directly on top of an already collapsing legal situation for this administration. It lands on top of 52 admitted court order violations by the Trump DOJ. It lands on top of a federal contempt order already issued against Bondi and Patel with jail as the consequence for non-compliance. It lands on top of a bipartisan congressional effort designed to force a court-appointed overseer onto the Epstein file release process, because Bondi and Patel demonstrated they could not be trusted to comply on their own. All of those things were already in motion before this ruling came down, and the Supreme Court just added rocket fuel to every single one of them simultaneously. Let me walk you through the full picture as it stands right now. We have a unanimous Supreme Court ruling that greenlights subpoenas for Trump's personal testimony and documents in the Epstein investigation. We have 53 withheld pages on Trump assault claims confirmed through independent NPR analysis. We have a bipartisan bill forcing court oversight onto Epstein file releases. We have Marjorie Taylor Greene publicly citing the Epstein cover-up in her departure from Trump's coalition. We have GOP donors in panic mode behind the scenes according to multiple leaks. We have a 32% approval rating sitting underneath all of this. And we have gas at $5 a gallon amplifying every single piece of this story into a working-class fury that is building and is going to be extraordinarily difficult to contain heading into the midterms. Now let's dig into the actual substance, because this story has multiple layers that all connect to each other in important ways. Understanding how they connect is what allows you to see the full picture clearly instead of just reacting to individual headlines in isolation. Start with the Supreme Court ruling itself, because it is the newest and most significant development. The court's rejection of Trump's blanket immunity claim in the Epstein probe is significant for reasons that go well beyond just this specific case and this specific investigation. The immunity argument, the claim that a president or former president has absolute protection from certain kinds of legal scrutiny, has been one of the central pillars of Trump's legal defense strategy across multiple active fronts. It has been deployed to delay proceedings. It has been used to complicate and slow down investigations. It has been used to create legal uncertainty in courts that might otherwise move significantly faster toward compelling disclosure and testimony. When the Supreme Court unanimously says that argument does not apply here, they are not just ruling on one subpoena in one case involving one investigation. They are closing a door that the Trump legal team was absolutely counting on staying open. They are sending an unmistakable signal to every lower court, every federal judge, every prosecutor handling any aspect of this matter that the immunity shield this administration was hiding behind does not exist in the way they claimed it did. That signal reverberates across every single active legal front this administration is currently fighting on simultaneously. The specific ruling that no blanket immunity shields ex-presidents from Epstein-related probes greenlights subpoenas for Trump's pre-presidency testimony and for documents covering his relationship with Epstein going back years before he ever entered politics. That is not a minor procedural development buried in legal footnotes. That is investigators now having a direct and legally unobstructed path to compel Trump himself, not just his aides, not just his appointed cabinet officials, but Donald Trump personally to produce documents and potentially testify under oath about his connections to Jeffrey Epstein. The wall is gone. The immunity shield is dismantled. The path is legally clear and wide open. Now connect that ruling directly to what NPR uncovered through their careful analysis of court filing stamps. 53 pages of documents that were deliberately withheld, specifically pages related to Trump assault claims. These were not pages that got accidentally misplaced in a massive document production exercise. These were not pages overlooked by an overwhelmed legal team. These were pages that were deliberately separated out, deliberately held back, while the DOJ was simultaneously representing to courts that it was working toward compliance with disclosure requirements. 53 pages on Trump assault claims specifically, deliberately hidden, while his own signed transparency law explicitly required their release. That combination, the deliberate withholding of the most sensitive and personally damaging material combined with the simultaneous public posture of working toward compliance, is what transforms this from a document dispute into a deliberate and targeted obstruction of justice. And the people who made the decision to withhold those specific pages are now sitting in the direct path of investigators who no longer have an immunity argument blocking their way forward. Now let's talk about the Massey Khanna bill, because this is genuinely the most underreported and underappreciated piece of the entire story. Republican Thomas Massey and Democrat Ro Khanna introduced legislation that forces a court-appointed overseer onto the Epstein file release process specifically and directly. Let me explain what that means in plain terms. Because Bondi and Patel had demonstrated through repeated and admitted contempt of court orders accumulating to 52 violations that they simply could not be trusted to comply with disclosure requirements independently. Congress moved to remove their unsupervised control over the process entirely. A court-appointed overseer operating with independent legal authority would supervise and enforce the file releases directly without requiring the DOJ's cooperation or good faith compliance as a prerequisite for anything actually happening. That is an extraordinary legislative step. That is Congress explicitly saying on the record, we no longer trust the Department of Justice of the United States to follow the law on this specific issue, and we are installing an independent watchdog with real legal enforcement authority to make sure the law gets followed whether DOJ cooperates or not. The fact that a Republican is leading this bipartisan effort tells you everything you need to know about how serious and how widespread the concern actually is on both sides of the political aisle right now. A bipartisan bill to strip the DOJ of independent control over Epstein file releases because they proved through 52 admitted violations that they cannot be trusted with that control. That is where we actually are. Now let's talk about the political dimension, because the legal developments and the political fallout are now colliding and accelerating in a way that is going to be very difficult for this administration to manage. Marjorie Taylor Greene publicly citing the Epstein cover-up as part of her departure from Trump's political coalition is something that matters in a fundamentally different way than any other Republican critic of this administration matters. Greene is not a moderate Republican trying to distance herself from Trump to appeal to suburban voters. She is not positioning herself for some post-MAGA political future independent of the base. She is the MAGA base, deeply embedded in it, deeply trusted by it, with a genuine and authentic connection to that specific coalition that very few elected officials anywhere in American politics can honestly claim. When she walks away publicly and specifically cites the Epstein cover-up as part of her reason, that signal travels instantly and widely through every corner of the conservative ecosystem in this country. And the people in those spaces, people who have defended Trump through everything, start asking questions they were not asking before. Questions like, what exactly is being hidden here? And why is it so important to keep it hidden that this administration would absorb all of this legal damage, all of this political damage, all of this institutional confrontation just to keep those files buried? The approval numbers are reflecting the full weight of this cumulative damage in real time. 32%. That is where Trump's approval sits right now according to current polling. 32% is not a number that reflects a coalition holding together under pressure. That is a number that reflects a coalition actively fragmenting. And it is happening against a backdrop of $5 gas, rising grocery prices, cost of living pressure crushing working families across the country. The economic pain and the Epstein obstruction story are not separate narratives for most voters who are paying attention. They combine into a single overarching and deeply resonant story that the people running this country are protecting themselves and each other from accountability, while ordinary working people struggle to make ends meet. That narrative, the elite protection narrative, is one of the most politically toxic things any administration can face. And this administration is facing it from every direction at once with a Supreme Court ruling that just made it significantly worse. The Supreme Court ruling has fundamentally and permanently changed the legal landscape of this entire situation, and there is absolutely no going back from it. When the Supreme Court unanimously rejects your central legal defense argument, that is not a courtroom setback that you recover from with a better legal team or a different strategic approach. That is a final and definitive answer from the final and definitive legal authority in this country. The immunity shield is gone, completely dismantled by all 9 justices simultaneously. Investigators now have a direct route. Courts have an explicit green light from the highest authority, and every other active legal proceeding connected to the Epstein files just received a significant boost in legal momentum and institutional legitimacy. The 53 withheld pages confirmed by NPR are the smoking gun that connects deliberate and targeted obstruction to specific protected content about a specific person. The analysis showing 53 withheld pages specifically related to Trump assault claims is not simply a document production dispute dressed up in legal language. It is direct evidence of targeted concealment designed to protect the most personally damaging material in the entire file set. Of all the pages and documents in these files, the ones that were deliberately separated out and withheld were precisely the ones most directly implicating Trump personally in the most serious allegations connected to Epstein's operation. That is not a coincidence. That is a deliberate decision made by someone with authority inside that DOJ to conceal specific material about a specific person. The political damage is compounding faster than this administration can respond to it. 32% approval, $5 gas, a unanimous Supreme Court ruling going against you on immunity, 53 withheld pages confirmed by independent journalism, a bipartisan congressional revolt producing real legislation designed to work around your DOJ's obstruction, Greene's public departure from your coalition, GOP donors in documented panic behind the scenes. Every single one of these things is feeding every other one of them. They are reinforcing each other. They are building toward a midterm environment that is going to be extraordinarily difficult for Republican candidates in competitive districts to navigate. What comes next is going to move faster and hit harder than anything we have seen in this entire story up to this point. With the immunity argument permanently gone, the pace of subpoenas and document production demands and potential testimony requirements is about to accelerate dramatically. More material from those files is going to enter the public record. The 53 withheld pages identified by NPR are going to become the subject of urgent and aggressive direct legal action now that the immunity shield has been removed. The court overseer mandated by the bipartisan bill is going to exercise independent enforcement authority that does not require Bondi or Patel to cooperate or act in good faith. The convergence of all of these pressures, all arriving simultaneously, is unlike anything this administration has faced before. Here is exactly where we land tonight. Unanimous Supreme Court ruling. Immunity rejected. Subpoenas for Trump personally now greenlit. 53 withheld pages confirmed on Trump assault claims by NPR. Bipartisan bill forcing independent court oversight onto Epstein releases. 32% approval. $5 gas amplifying the elite protection fury across every working-class community. Greene gone from the coalition. GOP donors panicking behind the scenes. Trump silent for 5 full days on the biggest legal ruling of his political life. This is not a story that slows down from here. This is a story that is about to accelerate into something this country has genuinely never seen before. And whatever comes next, it is going to define this administration, shape this moment in American history, and determine the midterm landscape in ways that cannot be easily reversed.